I know it's not all that late in the day, but it's going to get late in the day, and there are probably some other things that people would like to get done today. So I am instructed periodically to do a refresher on open meeting law and public records. Today we're just going to do open meeting law. At a later time we will do some public records discussion, but today it's open meeting law. I'll try to be concise, and we'll just do it quickly because I know most of you have been doing this for years, and you may feel very familiar with it. Make sure I'm doing this right. I think well.
I think one of them.
Richard, up there. You got it. Ha, good. Okay. I'm going to go back, though, because I want to pick up a couple more things here. Well, okay. A little bit of quick background on open meeting law. If you think back, way back, for those of you who are as old as me, and there's hardly anybody in here who is, back what was happening in this world, in our country in the 70s. Think about Nixon. Think about the Watergate plumbers. Think about all the things that were going on then, and Nixon's secret enemies list, and all the things that were happening. Out of that concern, and out of that era, grew a concern about private meetings and corruption in government, and hidden activities, and secret committees that were taking action that people didn't want them to take. And as a result of all of that, we developed nationally an open meeting law. They used to call them the sunshine laws because it let the light into the meetings. That was the idea. We spread from that into the states. By the time we got to the mid to late 70s, we had laws in almost all the states that meetings had to be open, the public had to be invited, that our activities in government were to be apparent to our constituents. Courts didn't like it, and committees didn't like it, and boards didn't like it, and so the courts began to construe these statutes very narrowly. And as a result, in the late 70s, 1978, Arizona's legislature went in and reinforced these laws and basically said they are to be construed broadly. That whenever there is a question about whether it's to be construed narrowly or broadly, it's to be construed broadly in favor of open meetings. Who must comply? Any public body. Boards, committees. Who's a public body? This is a public body. The Board of Trustees is a public body. State agencies are public bodies. I have done this little brief presentation, and it is brief, promise, it really is. Focus on this group. Now there are others, and I didn't put their particular statutes in here, like school boards, for example. They have some special rules that don't apply to us. So I am focusing primarily on us. This will be this kind of group, this board, and our local boards. Most of what's in here will also apply to local boards. What is required? Notice of meetings 24 hours in advance for most things. Ratifications, you'll see that's in there later, requires 72 hours in advance. A published agenda that's available to the public. The public is allowed to attend meetings, and minutes or recordings of public meetings must be taken. When is it a public meeting? Any of these groups, or subgroups of these groups. So when we have our Administrator Selection Committee, that is a subcommittee of this board, and so those are public meetings, and they have to be public meetings. So any of these kind, meetings, committees, groups, boards, chairmen, they all have to be noticed. Staff meetings are not public meetings. So an administrator can meet with his staff, a manager can meet with staff. Those are not public meetings. We don't have to put notices, we don't have to invite the public in, we don't have to have agendas. Okay? So managers and employees can meet together to conduct the business of the agency without having to create a public meeting out of it. Quorums. What is a quorum? A quorum is a majority of the members of the board. 4 of 7, 3 of 5, 2 of 3, 4 of 6. It has to be a majority. Now, is it a meeting if you don't have a quorum? Yes, but you can't vote. You can't vote unless there's a quorum present. Vacant positions do not reduce the quorum requirement. So if you have vacancies on the board, and I get those phone calls in my office from local boards who have a vacancy and they're suddenly going, we had 3 members, now we only have 2. Can we have a meeting? Well, 2 is a quorum of 3 for a board of 3. So if they normally would have 3, but they still have 2 members, they can still conduct business. But if they get below that, or if you're supposed to have, say, 4, and you only have 2, you no longer have a quorum. You can have meetings, but you can't vote. You can't take action on anything. So votes can be taken if a quorum is present, even if some members are absent, so long as you still have a majority of those who are eligible to vote present. That makes sense? If you have questions, stop me. So I'm going to go pretty fast because I know this is really new. Board members can be disqualified, usually by conflicts of interest. If you have a disqualification, what do? You can't count them for purposes of the quorum, for voting. Okay? They may not be counted for that item, but for other things they can. So you can still have your meeting, but they have to excuse themselves from that, which might mean that you don't have enough of a quorum to vote. By the way, all of this information is in a little PowerPoint, this one, that's going to be online for anybody to access, any of the employees or board that need to access it. I've tried to give you statute references too if you need to look at more, and then there's another reference too I'll give you later. Avoid splintering the quorum. What does that mean? It means that you can't avoid creating a meeting by saying, okay, I will call him and he will call you and you will call him. Don't do that. Don't do daisy chains, which means you call you and you call you and you call him. And don't. That's a daisy chain. Don't do it. Don't meet in little groups and talk about board business. It's a meeting. Even if you don't call it a meeting, it's still a meeting. If you have a quorum of the board there, it's a meeting. And you have to follow the normal meeting rules, which means notice and agenda. So be very, and you have to take records. You have to take minutes. You have to report it. So be very careful with that. Casual and if you meet together in casual or impromptu gatherings, don't discuss board business. So if you find yourself together at lunch, you see each other together after work somewhere, don't talk about business. Okay, that's the basic rule. Comments, questions? Not so far.
Yeah, I guess I have. But you can still, what we do at the county level, say Jeff and I, we're both on the operations committee. Let's say there's a training over here on an investment, and we both sign up for that seminar and we both go. At the county, that would be posted, because even though we're not going to conduct business, we're both in the same meeting and we're on our committee, we're a quorum, so we would just post it.
I would post it.
So if any of the members of the board, if there's a seminar in Albuquerque and 4 members sign up to go, then it should be posted.
It should be posted because you're very likely to end up discussing things that are now or will later be on an agenda. It gets a little tricky. Part of that is the reason why that courts started construing this more narrowly back originally, because it becomes very difficult sometimes to even conduct business. But we still are under constraints to do it. So it just behooves us to be careful. You can combine the notices of public meetings and executive sessions, or you can do them separately. Now, notices are important. Notices are not agendas, but you will post an agenda. But the notice says that you may combine. You notice there's a statute there, and I will show you in another source when we get to the end here. There are forms you can use for this. If you're ever concerned about how this should look or what the form should look like, there's a place to get the form. The AG's office has provided the forms for those. Agenda. You have to make the agenda available to the public. That's why they're on our front door. They have to be available to the public. And they have to be posted in such a place that they are legible from both sides, if printed on both sides. Or you can print them on one side and then put them behind. And they have to be non-removable. So that's why Michelle tapes them up there, so that somebody would have to come inside the building to tear them off in order to remove them. They have to be, you can't just put them outside on a poster board where the public could just tear them off and take them away. So it's kind of tricky about that. The board may only consider or discuss or decide matters that are on the agenda. Things not on the agenda can't be brought up or discussed. And there is a method for handling things that happen accidentally. They don't have to be discussed in order. As you can see in our meetings, we sometimes jump around. But we do have to, in some manner, dispose of every item on the agenda. Either deal with it or defer it to the next meeting so it'll be put on another agenda for a later meeting. And if you do that, you have to say so. That item number 20 or whatever will be deferred until the following meeting or will be put on an agenda for a later meeting. So you need to address them, but they don't necessarily all have to be handled in the meeting. If the meeting's running too long, you can defer them. Comments, questions? Again, I'm running kind of fast here.
Does that require a vote if there is a decision to defer, to table, to...
The chair can make that decision.
Okay.
The chair has that right. Okay. Optional items that can be on the agenda but don't have to. Consent agendas, we did consent agendas today. Consent agendas are usually those items that are, it says ministerial in nature. They're just administrative items that probably are not going to raise a lot of controversy. The public needs to be told that they're there. They have to be listed. The public has the right to ask further questions about them, and if so, then you need to respond to that. But in most cases, consent agenda items don't require a lot of extra work or help. You can take one vote to approve the entire consent agenda, which is intended to be a time-saving thing. Calls to the public are optional. You don't have to have a call to the public. If you do choose to have a call to the public, then you need to be a little bit aware that the board members cannot make a whole lot of response back. You're not ever supposed to get into a controversy back and forth with the public in a meeting. You can make a brief response to a question asked, but if it's something that's going to be more involved, then the board should simply say, we will take that under advisement and research it and get answers to you at a future time, rather than trying to deal with it during the meeting. Randy?
So, Ivy, and as a reminder, I come from a legislative background.
Right.
What is it in the, in the legislative process, if somebody from the public wants to speak on a specific bill, that must not be called to the public because that is an agended item. So what is the corollary here in this meeting?
There is a separate procedure in the statute for legislative sessions. But in this meeting, in terms of the corollary, we have a call to the public, and sometimes we have people from the public who want to make a statement, and they're permitted to make a statement. But then, again, I'm not sure your question. We don't really get into a debate with them or a close debate.
So is there not a mechanism to engage in discussion and debate with a member of the public on an item that is specifically on the agenda?
No, we do not debate with the public on items on the agenda. We take their responses and we research it, but we are not supposed to engage in a lot of back and forth.
But you're talking about call public, right?
Call the public.
Yeah.
I'm talking about an item on the agenda.
Well, see, that's one thing that's always kind of bothered me about these meetings. Personally, I think we should have a stack of cards over there, and Jeff comes in and says, I want to talk about, I have something I want to say on agenda item number 6. And when we get to 6, the chairman would have a card, oh, here's somebody who wants to talk on 6. I have no problem with that, and
But would we not be permitted to engage with them on agenda item 6?
You could do that if you have had a call to the public and a member of the public wants to address the board. That would be permitted. But on agenda items that are on the agenda.
Yes.
Right, items on the agenda.
So when it is an item on the agenda, somebody wants to address us on that item, that is a mechanism for us to ask them further questions or...
I think so, yes. If it's agendized,
Yes.
that item has been agendized. Like today we had our legal city in town. We can invite people in, or we can discover they're here and they want to address us about that particular issue. That can be done as a part of the call.
but see, we don't have a mechanism. How do you know? Just like when we open the meeting, the consent
It's already
agenda,
printed.
it says right here on the consent agenda that any board member can pull anything off the consent agenda if somebody wants to talk about it. Well, how do we know if somebody wants to talk about it? There might be somebody sitting over in the corner that's got a big deal with one of these items. You know what I mean? I mean, that's one thing, if I was chairman, no. I think we should have a card, so if somebody has a burning issue that they want to talk about, agenda item number 17, fine, I'm willing to hear what they got to say. I mean, I don't think it's that big of a deal.
I want to suggest that to your board.
Yeah, we'll talk. Did you get that, Mr. Chairman? Okay, he's got it.
Okay, matters not on the agenda. Okay, if a matter is not on the agenda, the best practice is to defer it to a later meeting. To say, we'll put that on the board for a later meeting and deal with it there. Actions taken at a meeting not on the agenda, on an item that's not on the agenda, are void. So in other words, action, we're not talking, actions are void. You can't vote and have it count if it's not on the agenda. You can't direct activity if it's not on the agenda. So what you would have to do is defer it. The best practice would be to defer it to a later meeting and deal with it there. Except if it's an emergency. There's an emergency that comes up. We discover that the building is flooding. We have a genuine emergency, or there's been a shooting, or there's been something else that we've got to deal with right now. Okay, you can do with that, and then there's a mechanism to ratify that later action. Ratification. You can't ratify a meeting, by the way. If you have a meeting you're not supposed to have, you can't ratify the meeting. You just simply had it, and it's a violation. But you can ratify an action. So if we end up accidentally taking action that wasn't on the agenda, we can ratify that action later. And there are several reasons that might happen. Sometimes they can make actual provision for that to preserve a date. Sometimes it's discovered that you need to approve a budget or approve an item because there's a deadline. There's going to be a penalty if you don't get it done. You can approve it now even though it's not on the agenda and ratify it later. And if you ratify it, it will be okay. It must take place within 30 days after you discover there was a violation. Okay. Questions? Okay, there's a procedure. I'm not going to go through all these. There's a procedure to ratify. The notice for ratification is 72 hours, not 24. If you're having a ratification meeting, you need 72 hours. There must be a public notice that states that this is going to be a ratification. You have to put that in the agenda, and then you have to have a description of the action, a clear statement that you are meeting to ratify a previous action taken in violation of the rules, and a description of all prior deliberations. So things you talked about before in connection with the action you took have to be listed. Executive sessions are always tricky, and it's like Las Vegas. What happens in executive session stays in executive session. It's not supposed to go outside of executive session. You can't have an executive session for just anything or any reason. They only convene for the purpose of discussing those 7 items that are listed in the statute for executive sessions. And here they are. I know maybe the way the light is, you can't see this really well, but again, you've got this on your computers, and I'm going to put it online, so we will have this here a little later. Certain personnel matters, and it can be discussed with the employee present. They need to be noticed. You have to give them a notice. Confidential records. There are certain records made confidential by statute. So discussing those confidential records that are made confidential by statute are done in executive sessions. Specific legal advice on specific matters. You can't convene an executive session just to talk about legal advice in general. It has to be about specific matters. So in other words, if we have ABC case going on, we can have an executive session to get legal advice on ABC case, but not just on general legal matters in general. And you can give instructions to attorneys. Normally, you can't have any vote in an executive session. No votes, no action, but you can give instructions to the attorneys in executive session about those specific matters.
So how do you do that without
voting?
Potentially voting?
Basically, usually the attorney will make a suggestion. You can say, I suggest to you that we engage in settlement offers. I suggest to you that a good program would be to file this motion. I suggest, and then the board or board chairman can say, you're not going to vote on it, but you're going to say, the chair would say, the board directs you to take that action.
And then is there any requirement when you come out of executive session to acknowledge?
Basically, at that point, you take a vote. You come out of executive session, you take a vote that basically says that we, the board, direct our attorneys to take the actions that to follow the instructions we gave to them in executive session. Peter,
Without revealing what the subject matter
without
is.
specifically revealing. I have some other experts here, so correct me if I step the line. Okay.
And then I want to ask you about the purchase or sale of real property,
Right.
because I assume, as I understood that authorization in an executive session is so you don't tip your hand. We want to sell
That's
building A, and we're willing to go as low as $1 million for it. You don't want to announce that to the world.
No. Basically, you can't do the actual negotiation in executive session, but you can discuss whether this is not like our investment team doing. This is like the board decides to buy another building to move our operations into, that kind of thing.
Right.
But you can do other kinds of real estate things too, but you don't actually do the negotiation. But
you can set a framework for where you're willing to go. And then what's the public meeting follow-up on that?
The public meeting follow-up would be similar to the legal counsel, that the board would vote to take the action that was discussed or recommended.
Or to enter into a negotiation with the framework that we discussed?
As long as we're careful that we don't reveal the details in executive session that we should not have revealed.
Because we still don't want to say we're willing to buy it for $5 million, but we're hoping to get it for $3.
That's right. So other things here that really don't pertain too much to us, but they're part of the reasons you can have one is discussion with union representatives or other representatives of labor organizations. We don't deal too much with that. International, interstate, and tribal negotiations we don't deal much with, and then real estate. Okay, convening before you go into an executive session, there must be a motion to go into executive session. The board's in charge of that. And the chair is supposed to make a little announcement when he convenes the executive session, basically inviting everyone else to leave, specifically stating who is to remain in the room, asking everyone to take themselves and their property, including backpacks, purses, and personal items, out of the room so that there will not be the possibility of a recording device left in the room. So when you make that announcement and move into executive session, you should invite people to take everything with them and make sure that they go before you start.
Ivy?
Just a question. Going back to the last page, what's the purpose of the recording of the executive session on a recorder? And what's proper disposition of those? I won't even call them minutes, but
They are minutes, and we are required to keep minutes.
okay. And who takes those minutes then?
We don't actually.
The tape recorder? So there is no secretary then?
The executive session is recorded. There is no secretary unless one of the board members wants to do that.
Okay.
But we record them, and then afterwards the recording is locked up in a safe, and they're not transcribed. We don't transcribe them.
So then what happens to them?
So what happens is they stay in the safe unless a member of the board or somebody who's in the executive session or certain very specific people ask for access to them, and then they can listen to them. But only very specific people, and I have another little list here.
Okay, so if you're a board member, you couldn't ask to hear the minutes of an executive session that occurred prior to your being on the board because you didn't participate in it.
Go ahead.
Mad at me if I disagree with you.
Yeah, I disagree with that too.
Yeah, I researched this issue for this board, and any board member is entitled to hear the executive session minutes of prior boards.
Okay.
And the reason is you're acting as an institutional body, so the body needs to have full knowledge of what's going on.
Okay, thank you. All right. In executive session, you can only discuss those matters that are on the agenda for the executive session. They're listed, and you can see how we do it on this agenda. You may not take a vote in the session, may not take straw polls or informal votes, and the chair is then responsible for adjourning the executive session and going back into the public session. Meeting minutes. There are minutes or recordings of public sessions, and those are pretty much publicly available. They're supposed to be available within 3 working days after a meeting, and they have to include these things: the date, time, and place, all motions, who made the motion, what it was about, all actions taken, votes taken, and so forth. And if non-agenda items were discussed or ratification was taken, a full description must be included in the minutes. Executive session minutes, here we go, contain the same essential information but an accurate description of any instructions that were given to attorneys. And that has happened once or twice where an attorney needed to confirm what the instructions were. It's a little tricky sometimes. But what were the instructions that were given in this meeting? And those can be accessed. There are a few other people who are allowed to see them. They may inherit the disclosures. And I didn't know that the body, but that makes sense, that the body is acting as a body and not as individuals. But okay. Any member of the board, regardless of whether that might cover that, whether or not they attended that executive session, can see them. A portion of the minutes to officers, appointees, or employees who were the subject of discussion. That portion of it, if they participated in or were discussed or they were the subject of that meeting, they can see that portion of the executive session minutes. Staff is necessary to take care of the minutes. Well, we don't do that here because we don't want to expose them more broadly, and it's rare that anybody really wants to go back and refer to them. But if we could assign someone to transcribe the typo, but we choose not to do that. But staff is permitted to do that as necessary. Here, we just take the recording and lock it up. The attorney for the public body as necessary to represent the public body. And so that's not really just for all purposes or anything that somebody has a curiosity about. But the public body's attorney can see those minutes as necessary for representation. The Auditor General can see them. And we can one time a request for somebody from the Auditor General's office to see an executive session minutes. And they are permitted to disclose those. The Attorney General or County Attorney only when investigating alleged violations of the open meeting law. That's not when they're investigating everything else or anything else. It's like when they're investigating violations of the open meeting law, you can look at those minutes. And the court, for purposes of public inspection, when a violation has been alleged. We're all talking about violations of the open meeting law, not just all kinds of violations. Okay, what happens if we violate these rules? There are sanctions. The Attorney General's office is specifically tasked with enforcing the open meeting law. They have that responsibility given to them by the legislature. And in order to do that, they have created this committee called the Omelet Committee, the Open Meeting Law Enforcement Team. And they visit public meetings. They sit in sometimes on executive sessions. They do these kinds of things to verify what we are doing in our open meetings. And if we have a violation, we're supposed to report it ourselves to Omelet. And that's kind of a tricky thing, but you need to be very careful and know, you need to report carefully what you've done and how you plan to correct it. Try not to have too many of those violations. There are penalties. Penalties can be not exceeding $500 per person for each violation. That's not assessed against the board, it's assessed against the persons. It's a personal liability, so it's not something we really have to do. And the court may order payment of reasonable attorney's fees to someone who is successful in proving a violation of an open meeting law that harmed them. Okay, here I've given you, and I know you can't see that, but it's in your other materials to print out. There's the statute, okay, the whole statute, and it's a lot longer than what I have summarized here. But down at the bottom, there is a link, and the link is to the Arizona Attorney General's Agency Counsel Handbook. And that has lots of things in it besides open meeting law. It has lots of material in it, but it is available to the public online. It was designed and written for Assistant Attorney Generals who go out and do what I do. But since then, they've decided there's so much useful information that other people need that they have chosen to make it available to the public. So there is a link. Any member of the public, including you, can go there. There are things in it about confidential records, about open meeting law, about representation, legal representation, about all sorts of things that pertain to state agencies and how the legal framework of the various state agencies work together. So I'm making, and there's a whole chapter on open meeting law. So I'm making that available to everyone who might have anything to know about it or to access that. So there are forms in there, forms for notices, forms for agendas, forms for all sorts of things, forms for ratification. So you can see what they should look like. And then there's a lot more information than I put in this little presentation, which is lots of minutes. Pretty extensive. Okay, questions, comments, additions, subtractions?
Anybody have any questions?
We truly can subtract things?
You can subtract these from my presentation, not from the open meeting law. But if I said something you want to subtract, okay.
And, you know, you touched on one of my favorite, one of my burning issues, executive session, looking at the minutes. And it's Picture Rock Fire District versus Updike,
Right.
1985. It says any member of the public body, regardless of whether he or she attended the executive session, can see the minutes.
That's right. That means the board.
Right, the board, a sitting
That's
member.
the board, that's not like the world.
Right.
But that's true because, you know, and I didn't even touch upon the fact that you can participate in these things telephonically. There are other things that you can do, I mean, without sitting here. And so you are entitled to know what goes on in executive session, whether or not you are specifically in that session as a board. Now, and that also applies to, you know, your subcommittees of the board. We have operations committee, we have investments committee, we have this administrator search committee. Sometimes we have other committees for other reasons. Those are official committees, and they have to follow these rules. You could theoretically have an executive session, but usually you won't because we're smaller groups.
Anybody have any questions? I guess the main takeaway for all this is if any of us are going to go to a conference or anything, and you know another board member is going to be there, it doesn't hurt to call up here and have it posted. That's the thing.
Mr. Chairman, just a question on that. So in some cases, the conferences are a couple days long. Do you just post the location for the 2-day period and just leave it open?
Sure. We're having a 2-day meeting now. This is a 2-day meeting. We posted it. Location, has to be location, etc. Yes.
Although on this subject, I understand that the better course, if you know that that's going to happen, is to post it. But the fact that 3 of us show up at an event at the same time is not necessarily a violation of the open meeting law, correct?
Especially, it wouldn't be if you don't discuss board business.
Right. I mean, and I'm not suggesting we do this, but, you know, even if, you know, Bill, Greg, and I stand there together talking about our kids, we haven't violated anything.
Well,
I understand the better course
if it's, well,
talking about our kids.
but then you don't have a quorum, so it's not a problem.
All right, Jeff's there too.
Well,
I mean, I understand the better course is if you know it's going to happen, the appropriate thing to do is
Well,
post
he's
it to
there, I'm
give
not
notice. But you haven't per se violated it because you're in the same place.
You know, if it was an impromptu or casual meeting without any discussion of board business, not a problem. It wasn't planned. You happen to meet each other in the grocery store line. You don't have to post that. But then don't step across the line and start
Agreed.
discussing board business. Don't
Yes.
poll each other for votes. What do you think about that? Should we? No, just stay off the subjects so that you're safe. If you do end up having those kinds of meetings, and especially if you make some decisions at those meetings or take any kind of formal or informal poll, you have created a violation. We're going to have to report it. It's not a fun thing.
I do not intend to go there, and I appreciate that. I did understand the one thing that you could sort of do with a reply all is availability for a meeting.
Yes, I did put that. And
Okay.
there's lots of little details I didn't want to take the time to put into this, but yes, you can send out meeting invitations. A meeting invitation is not a violation. How else do we let people know we're having a meeting? So we can send out a meeting invitation, but don't attach information. In other words, don't say, oh, and by the way, what do you think about? No, don't. Just put the meeting time and place there, and then people are coming. Just be discreet. Just be careful. That way we don't ever have these problems if we are on the street. Remembering that, if you are going to have a meeting, that's why a couple of times we want to have special meetings, or we wanted to get together for a working session, or we wanted to have a committee meeting, that we have to post it. We have to give us 24 hours notice at least. And Michelle actually does the notices, and she's busy, so don't call her at the last minute and say, I've got to have we've got to have this posted by tomorrow. It's difficult for her to get it up in time, so give her time to get it posted. Comment.
I'm doing it.
Kathy do it too, great. So, that will help. That helps. Anything else? And Don, seeing something back here, this would be great for your local boys. You're welcome to share any of this with your local boys. That's good. Is that it?
Okay, yep, thank you very much.
Thank you.
There is a whole other side of this too, like in my world. If I don't get invited to something, I don't go, because some organizations will invite 2 supervisors because they don't want to post it as an open meeting. So, because a lot of organizations will purposely pick and choose who they invite because they don't want it posted. That makes sense. So,
And they wouldn't, it's not for any reason an open meeting except for the fact that they have more than a quorum of a
Yeah.
governing body there.
yeah.